Yeah, how are you?
Oh, let me stay here since when we stay here. Come, please. Okay.
What's the extradition issue about Nnamdi Kanu?
Yes, this is Nnamdi Kanu's case, yes, which is a recurring decimal in our judicial process since 2015, and it will continue to be until the courts do the needful and the government does the needful. This particular one is an originating summons, which was filed on the 7th of April, 2022. And it was before this honorable court, the Honorable Justice Inyang Eko of the Federal High Court, Abuja. Essentially, we are asking for determination of certain questions. Whether the extraordinary rendition by force, after torture, after blindfolding, after being chained, after being put in an isolated, solitary confinement of Nnamdi Kanu from Kenya, where he had voluntarily entered as a British citizen on the 19th of June 2021, and then forcibly renditioned back to Nigeria on the 27th of June 2021, whether it occurs with local and international laws, and whether it occurs with Section 15 of the Extradition Act, Laws of the Federation of Nigeria, 2004. We are invoking what we call the doctrine of specialty also. Our contention is that only extradition proceedings will enable you bring back a citizen from another country to Nigeria, or from Nigeria to another country. Indeed, we give the example of this police officer, Abba Kyari, who, when America wanted him for certain crimes, it was the Attorney General here who said he could not be extradited because a case had already been filed against him here. On the contrary, it is the same Attorney General that masterminded the forcible extraordinary rendition of Nnamdi Kanu from Kenya to Nigeria, without following due process, without following the extradition process. And the Kenya government, in a suit which we have exhibited, made it clear that they never consented for Nnamdi Kanu to be renditioned back to Nigeria. We have also attached a document which is a foreword written by the Attorney General to a book where he strenuously and stringently condemned forcible extraordinary rendition as being illegal and unconstitutional and against all known norms of local and international laws. We have attached that document. We are also contending that under the doctrine of specialty, when a person is brought back, even if done properly through normal extradition, you can only try him for the offenses for which you are extraditing him, or for lesser offenses, but not for offenses that were going on before he was brought in. And from all evidence before the court, the only charge that was before the court, before the extraordinary rendition, were only 5 counts, and none of them bordered on terrorism at all. It was only after they brought him back like a common criminal, like the way they tried to do to Alhaji Umaru Diko during the time of Buhari, after he overthrew President Shehu Shagari, and the man was drugged and put in a crate before eagle-eyed British police officers discovered him in a crate, drugged. That one was unsuccessful. Even then, some people were convicted for that inhuman and degrading act. So, ironically, it is under the same Buhari, this time as a civilian democratic president, that we are also seeing this happening. So, it was after he was brought back, Nnamdi Kanu was brought back, that they amended the 5-count charge, first to 7-count charge in January last year, and then again to 15 counts. Don't forget that this government that said they were ready to prosecute Nnamdi Kanu, whether for acts of terrorism or non-terrorism, have amended their charge 7 times, 7 whopping times. One of the reasons I'm going to crusade seriously from now onwards for the amendment of the Administration of Criminal Justice Act, ACJA. You cannot say a prosecution can continue forever to amend the charges. You are supposed to have investigated the case thoroughly, and you are sure-footed that a person has committed a crime before charging him to court. Why should ACJA give an open-ended permission to the prosecution to continue to amend? At times they even amend to accord with evidence already laid. That is not good for the defendant. That is not a good law. I'm going to crusade for an amendment of that portion of the Administration of Criminal Justice Act of 2015. Now, after they now amended to 15, we came to the Federal High Court here before Justice Binta Nyako, who struck out 8 of the 15 counts. The remaining 7 counts, we were not satisfied. We took them to the Court of Appeal. That is why I told you that the case is a recurring decimal. We won at the Court of Appeal again. The remaining 7 counts were struck out by the Court of Appeal. More importantly, the Court of Appeal made an order that Nnamdi Kanu was discharged. In other words, having now been discharged of the remaining 7 counts plus the other 8 counts, it means that Nnamdi Kanu became a free man, as free as the air. Not only that, the Court of Appeal made a very, very historic and prodigious pronouncement. They said Nnamdi Kanu should never again be arraigned in any court of law in Nigeria on any of the existing counts which had now been finally dismissed. And that more importantly, he should never again be detained. In other words, from 13th of October 2022, when the Court of Appeal delivered that judgment, Nnamdi Kanu became a free man. But the federal government surprisingly went to the same Court of Appeal before another panel to obtain an order for stay of execution. So we are having a sorry situation, a very, very pathetic situation, where the federal government of Nigeria, a whole federal government of Nigeria, went to court to get an order for stay of execution of the liberty of its own citizen. Because that is, in effect, what the order meant. Compare with America, for example, from where we borrow our presidentialism. America will go to a country. They will go and take out their citizen, even if kept in a cell, a solitary confinement, because they believe in the humanity of their citizens. But here is a federal government dehumanizing its own citizen, committing acts of terrorism.